All senators, please indicate your presence. A quorum is present, Mr. President.
Good afternoon. Senate will come to order. Senators and guests in the gallery, please rise for the opening prayer, be given this afternoon by Brian Campbell, pastor of the Greater Macedonia Baptist Church, Jacksonville, sponsored by the Minority Leader, Senator Gibson.
Let us pray. Most holy and gracious God, our Creator, Sustainer, we thank you for allowing us to gather for this legislative session. It is our prayer that your divine presence will rest upon this place, that you will lead and direct all deliberations and discussions that will take place during this session. Let us always be mindful of those that we represent, and let us keep their best interests before us. Let us not allow divisive language and attitudes to keep us from doing the business of the people of this great state of Florida. Let the spirit of unity and oneness bind us together as we move forward in this session. Allow us to make our state as a positive example for other states in this country. Allow us to show others the love still conquers over hate, and we can do more together than apart. Bless each member of this body with wisdom and knowledge needed to make this session one of the greatest sessions ever. Bless the majority and minority parties that they'll be able to come to compromise that will benefit the people of our state. We thank you for every staffer and every worker. Bless our governor and continue to bless our great state of Florida. In thy name we pray. Amen.
Amen. Senators, please remain standing for the Pledge of Allegiance to be led this afternoon by the Senate pages. The Senate pages are as follows. Aislinn Baker of Ocala, sponsored by the Senator of the 12th District, Senator Baxley. Wyatt Ballardo of Vero Beach, sponsored by the Senator of the 17th District, Senator Mayfield. Liam Fineout of Tallahassee, sponsored by the Senator of the 34th District, Senator Farmer. And Zandrick Pennywell of Midway, sponsored by the Senator of the 3rd, Senator Monfort. To the flag of the United States of America, and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Senators, the doctor of the day is Mark Dobertine of Orange Park, sponsored by the Senator of the 5th, our Appropriations Chair, Senator Bradley. Dr. Dobertine specializes in general surgery. Welcome. Okay, let's return to the order of business, Madam Secretary. Are there reports of committees?
None on the desk, Mr. President.
Are there motions relating to committee reference?
None on the desk, Mr. President.
Are there messages from the governor and other executive communications?
None on the desk, Mr. President.
Are there messages from the House of Representatives?
None on the desk, Mr. President.
Are there matters on reconsideration?
None on the desk, Mr. President.
Thank you. Senators, before we take up the special order calendar, it's my understanding, and where's the Minority Leader Gibson? Saw her just a minute ago. Anyways, my understanding that Leader Pasadomo and Leader Gibson have agreed to roll marijuana today, as well as all of the other bills on the special order calendar to third reading for a final vote. Am I correct? Leader Gibson?
Yes, Mr. President.
Thank you. Okay, let's go to the special order calendar. Call up the first bill.
Senate Bill 2, a bill to be entitled An Act Relating to the Florida Statutes.
The Senator of the 27th District, Rules Chair Benaquisto, is recognized to explain the bill.
Thank you, Mr. President. Senate Bill 2 is the Adoption Act for the Florida Statutes. It is enacted in each regular session as an essential element of the continuous statutory revision program. The bill prospectively adopts Florida Statutes 2019 as an official document and, more importantly, adopts as the official statute law of the state all statute material passed through the 2018 regular session and printed in the 2018 edition of the statutes.
Are there amendments?
None on the desk, Mr. President.
Are there questions of the sponsor? Questions of the sponsor? Seeing no questions, the Senator of the 27th District, Rules Chair Benaquisto, moves that the bill be read a third time by title, having without objection received the required 2/3 vote. Please read the bill a third time.
Senate Bill 2, a bill to be entitled an act relating to the Florida statutes.
Is there debate on the bill? Seeing no debate, is there a close? Senator Benaquisto.
I'll waive my close, Mr. President.
The Secretary will unlock the board. The Senators will prepare to vote. Have all Senators voted? Lock the board and record the vote.
37 yeas and 0 nays, Mr. President.
Show the bill passes. Senator from the 27th, Rules Chair Benaquisto, or read the next bill. Come on, this is a maiden voyage up here. Read the next bill.
Senate Bill 4, a reviser's bill to be entitled an act relating to the Florida statutes.
Senator of the 27th, Rules Chair Benaquisto, you are recognized to explain the bill.
Thank you, Mr. President. Senate Bill 4 is a general reviser's bill, which deals with miscellaneous subjects of a technical, non-substantive nature, corrects grammatical, typographical, and cross-reference errors.
Are there amendments?
None on the desk, Mr. President.
Are there questions of the sponsor? Seeing no questions, the Senator of the 27th, Rules Chair Benaquisto, moves that the bill be read third time by the required 2/3 vote. Seeing no objection, show the motion adopted. Read the bill a third time.
Senate Bill 4, a reviser's bill to be entitled an act relating to the Florida statutes.
Is there debate? Senator Benaquisto, you are recognized to close.
I'll waive my close, Mr. President.
Secretary will unlock the board and Senators will prepare to vote. Have all Senators voted? Secretary, lock the board and record the vote.
38 yeas and 0 nays, Mr. President.
Show the bill passes. Senator of the 27th, Rules Chair Benaquisto.
Thank you, Mr. President. Senate Bill 6 deletes statutory provisions that have been repealed by a non-current session of the legislature, where the repeal or expiration date has now occurred, rendering the provision of no effect.
Are there amendments?
None on the desk, Mr. President.
Are there questions of the sponsor? Seeing no questions, the Senator of the 27th District, Rules Chair Benaquisto, moves that the bill be read third time by the required 2/3 vote. Is there objection? Seeing no objection, show the motion adopted. Read the bill.
Senate Bill 6, a reviser's bill to be entitled an act relating to the Florida statutes. Senate Bill 6, a reviser's bill to be entitled an act relating to the Florida statutes.
Is there debate? Seeing no debate, Senator of the 27th waives close. The Secretary will unlock the board. The Senators will prepare to vote. All Senators voted. Secretary, lock the board and record the vote.
38 yeas and 0 nays, Mr. President.
Show the bill passes. Read the next bill.
Senate Bill 8, a reviser's bill to be entitled an act relating to the Florida statutes.
The Senator of the 27th, Rules Chair Benaquisto, you are recognized to explain the bill.
Thank you, Mr. President. Senate Bill 8 amends and repeals sections of the statute which grant redundant or unused rulemaking authority.
Are there amendments?
None on the desk, Mr. President.
Are there questions of the bill? Seeing none, the Senator of the 27th, Rules Chair Benaquisto, moves that the bill be read a third time by the required 2/3 votes. Is there objection? Seeing none, show the motion adopted. Read the bill.
Senate Bill 8, a reviser's bill to be entitled an act relating to the Florida statutes.
Is there debate? There debate. The Senator of the 27th waives close. Secretary will unlock the board. And all members will vote. All members voted. All members voted. Secretary, lock the board and record the vote.
38 yeas and 0 nays, Mr. President.
Show the bill passes. Read the next bill.
Senate Bill 180, a bill to be entitled an act relating to lost or abandoned personal property.
The Senator of the 22nd, Senator Stargell, you are recognized to explain the bill.
Thank you, Mr. President. SB 180, Lost or Abandoned Property, assists both law enforcement agencies and businesses in our tourism and hospitality industries by easing the burden they currently have when processing large volumes of lost or abandoned property. Currently, they have to turn their property over to law enforcement officers. It has to be held by law enforcement officers for 90 days. After 90 days, the finder may make a claim to the property. Cumbersome process. What this bill does is creates an exemption for businesses in the hospitality and tourism industry, specifically theme parks, entertainment complexes, zoos, museums, aquariums, and allows them to handle the lost and abandoned property to be held for 30 days by the owner or operator, and after the 30 days, the property can be donated to a charitable organization or disposed of.
Are there amendments?
None on the desk, Mr. President.
Are there questions of the sponsor? Questions of the sponsor? Seeing no questions, the Senator of the 22nd District, Senator Stargell, moves that the bill be read a third time by the required two-thirds vote. Is there objection? Being no objection, show the motion adopted. Read the bill.
Senate Bill 180, a bill to be entitled an act relating to lost or abandoned personal property.
Is there debate? Is there debate on the bill? Being no debate, the Senator of the 22nd, you are recognized. Waves closed. The Secretary will unlock the machine, and the Senators will prepare to vote. Have all Senators voted? All Senators voted. Madam Secretary, lock the board and record the vote.
38 yeas and 0 nays, Mr. President.
Show the bill passes. Read the next bill.
Committee substitute for committee substitute for committee substitute for Senate Bill 182, a bill to be entitled an act relating to the medical use of marijuana.
Senator of the 24th, Senator Brandes, you're recognized to explain the bill.
Thank you, Mr. President. I thought I would take us back a little bit in history and kind of walk through how we got here, and then proceed to the bill and the amendment. On Amendment 2, on November 4th of 2016, was voted into law and established as part of the Florida Constitution. This section of the Constitution became effective in January of 2017. Subsequently, the legislature passed Senate Bill 8A in special session of 2017. The bill revised the Compassionate Medical Cannabis Act of 2014 and implemented the amendment. Senate Bill 8A defined the term medical use to exclude smoking. And this provision became known as the smoking ban, was challenged in the circuit court for the Second Judicial Circuit in July of 2017. But the People United for Medical Marijuana, Inc. challenged the smoking ban on 2 counts. On May 25th of 2018, the judge issued an order agreeing with the plaintiffs on both counts and ruling that the smoking ban was unconstitutional. In her order, the judge held that qualifying patients have the right to use the form of medical marijuana for treatment of their debilitating medical conditions as recommended by their certifying physicians, including the use of smokable marijuana in private places. The Department of Health appealed the ruling in the First District Court of Appeal on May of 2018, and the appeal is currently ongoing. However, in January, Governor DeSantis held a press conference in which he announced his intentions to withdraw from the appeal should the legislature not act to remove the smoking ban from the Florida statutes by mid-March of 2019. So that is what has led us to file this legislation, and we would like to move to the bar-coded amendment, and I'll explain the bar-coded amendment, which will essentially become the bill.
Read the amendment.
Bar Code 897266 by Senator Brandes, delete everything after the enacting clause and insert amendment.
Senator of the 24th, you are recognized to explain the amendment.
Thank you, Mr. President. The amendment requires submissions to submit documentation to the applicable board after certifying that a patient to smoke marijuana. This process will aid the Board of Medicine and the Board of Osteopathic Medicine in creating practice standards for smoking marijuana as required in the bill. The documentations include the routes of administration the patient has tried, if any, their effectiveness, research on the effectiveness of smoking medical cannabis, a statement that the physician's opinion that the benefits of smoking marijuana outweigh the risks. It maintains that the physician may certify a patient under the age of 18 to smoke medical cannabis only if the patient has terminal condition. The amendment specifies that the certifying physician must obtain written informed consent of the patient's parents and guardians using a form adopted by the Board of Medicine. This largely complies with the Florida right to try provisions. It allows a physician to apply to the DOH for an exception to the 2.5-ounce purchase limit and the 4-ounce possession limit for qualifying patients. Some patients with Lou Gehrig's disease and other diseases may need more, and we need to create a pathway for them outside this current pathway, and so that's what this provision allows. It allows for the board to research the consortium, to fund research through a teaching nursing home on the effectiveness of medical cannabis on age-related conditions, and if the teaching it does not require MMTCs to sell pre-rolled marijuana cigarettes, but if an MMTC does sell such cigarettes, it may not use hemp tobacco wrappings. The MMTC may sell paper wrappers, but it may not sell pipes or paper wrappers made from hemp or tobacco. It specifies that nothing impairs the ability of any party to restrict smoking or vaping marijuana on his or her private property. It requires a consortium for medical marijuana clinical outcomes research to be established in a state university designated by the Board of Governors. It removes and repeals the proviso provision that we had in the previous version of the bill that passed out of appropriations. And it adds a $1.5 million in recurring GR to the Board of Governors and the consortium for the purposes of research. That is the amendment.
Are there amendments to the amendment?
On the desk, Mr. President.
Read the first amendment.
Bar Code 733576 by Senator Brandes. Delete lines 14 through 15 and insert amendment.
Senator of the 24th, Senator Brandes, you're recognized.
Thank you, Mr. President. This amendment clarifies that the authorization to purchase delivery devices from vendors other than the MMTCs applies only to the delivery of devices for medical use of marijuana by smoking.
Are there questions of the amendment sponsor? Questions of the amendment sponsor? Being none, is there debate on the amendment? Debate on the amendment. Senator Brandes, you recognize close on the amendment.
I'll waive.
Waives close. Senator Brandes, having waived close on the amendment to the amendment, all those in favor signify by saying yea. Yea. Opposed, nay. Show the amendment adopted. Read the next amendment.
Bar Code 264942 by Senator Brandes. Delete line 181 and insert amendment.
Senator Brandes, you recognize to explain the amendment.
Thank you, Mr. President. This increases the 35-day supply that a physician may certify to a patient to receive at a single office visit from 1 to 6. So they may have 6 35 days periods before they have to come back to their physician.
Are there questions of the amendment sponsor? Questions of the amendment sponsor? Is there debate on the amendment? Debate on the amendment. The amendment sponsor having waived his close. All those in favor of adopting the amendment signify by saying yea. Opposed, nay. Show the amendment adopted. Read the next amendment.
Bar Code 219464 by Senator Roussan. Delete lines 289 and 290 and insert amendment.
Senator Roussan is excused this afternoon, so the senator from the 33rd, Senator Thurston, you are recognized to present the amendment.
Thank you, Mr. President. This amendment simply adds oversight from the Department of Agriculture and Consumer Services to the effectiveness of an applicant's medical marijuana diversity plan, included in their application for initial licensure and licensure renewal of MMTCs. It also directs the Department of Agriculture and Consumer Services to submit an annual report on the effectiveness of MMTC's diversity plans to the Governor, the Senate President, and the House Speaker. The Department of Agriculture and Consumer Services supports this initiative. This is an important provision we are hearing because we're having major concerns about the Department of Health just checking the box and not having any follow-up on the diversity plans of the MMTC's owners. Across the state of Florida, African Americans are 4 times more likely to be arrested for possession of marijuana. From a county-wide perspective, several counties have experienced even higher numbers. According to the Tampa Bay Times in Pinellas, Hillsborough, African Americans are 6 times more likely to be arrested. Gainesville Sun, cited by the ACLU, found that 6.6 times more likely. Additionally, Sarasota County has the largest disparity in the state, where African Americans are 10 times more likely to be arrested for marijuana possession. Therefore, we find the need to have this compliance, to make sure it's not just a check in the box and we don't get back to it. But to be sure, Senators, there's a need for serious discussion not only on the compliance, but there's a need for a discussion of the MMT licensing procedure as a whole. Vertical integration is simply not working for Floridians, and it's certainly not working for my community. I've spoken with the bill sponsor about this very important legislation that we have here today, and because of our discussion, and we're looking to make some improvements and actually have that serious discussion about vertical integration, I'm going to be withdrawing this amendment at this time, but I thank you for hearing us on this issue. Thank you.
Show the amendment withdrawn without objection. Before we read the next amendment, Senator of the 1st, Senator Broxson, understand you have an introduction.
Mr. President, it's my great honor to welcome to the chamber in the East Gallery the Mayor of Milton, Heather Lindsay.
Welcome. Welcome to the Florida Senate. Read the next amendment.
Bar Code 320934 by Senator Brandis, delete lines 761 through 767 and insert amendment.
Senator of the 24th, Senator Brandis, you recognize.
Thank you, Mr. President. This simply clarifies that the Coalition Board must collaborate with, in addition to being authorized to provide funds to, a teaching nursing home in conjunction with research on the effects of marijuana on age-based conditions. That's the amendment.
Are there questions of the sponsor? Questions of the amendment sponsor? Is there debate on the amendment? Debate on the amendment. The amendment sponsor, Senator Brandis, of the 24th, waves his close. All those in favor of adopting the amendment signify by saying yay. Opposed, nay. Show the amendment adopted. Show the amendment adopted. Read the next amendment.
Late filed Bar Code 944380 by Senator Farmer, between lines 288 and 289, insert amendment.
Senator Farmer of the 34th. This is a late filed amendment. Requires 2/3. Show that introduced without objection. Senator Farmer, you are recognized to explain the amendment.
Thank you, Mr. President. This amendment is designed to facilitate access to this new legal medicinal treatment. And it is designed to encourage our veterans who are suffering from things like PTSD and pain syndromes related to their service to our country. Anything we can do to alleviate the reliance on opioid medication, I think we all would agree is good policy. And so what this amendment would do would be provide free medical marijuana access cards to our veterans so that they don't have to incur that fee. And it just makes this potential optional treatment more readily available to them and potentially encourages them maybe to not go on opioids, at least not at the first step. And of course, all of these decisions would be made through the advice of a physician and the patient consulting together. And I believe this is an important issue we should take up. I've discussed it with the sponsor. I think he is very understanding and sympathetic to the concept, but we also understand that we're on a small time frame here to comply with the governor's request on this issue, and we're dealing with our friends across the rotunda on some sensitive issues here. So in the interest of advancing this legislation and not bogging it down, I'll be withdrawing this amendment, but I do look forward to offering it again and perhaps including it in your licensure bill as we move forward. Thank you, Mr. President.
Show the amendment withdrawn without objection. Read the next amendment.
Late filed barcode 299090 by Senator Farmer. Before line 5, insert amendment.
Late filed amendment requires 2/3 for introduction. Show it introduced without objection. Senator of the 34th. Senator Farmer, you recognize to explain the amendment.
Thank you, Mr. President. And this amendment, as well as the next one that I'll be talking about, again, sort of the theme here is this is a new concept for a lot of folks, that marijuana is now a legitimate medical option. It's medical treatment. It's Tylenol. It's any other kind of medicine you could be prescribed or that you could buy over the counter. But we want to make sure that people aren't discriminated against for resorting to or choosing to implement this legal medical treatment. And so what this amendment would do would limit an employer's ability to terminate an employee who tests positive for marijuana in a drug test, who is a licensed card holder. Now, the amendment would provide that employers can terminate an employee if they're using marijuana on the job and it affects their job performance. But simply because they're obtaining relief from pain or whatever other condition they have at night in the privacy of their own home and they are a legal card holder, if they are subject to a random drug screen, they shouldn't be fired because they test positive. And so, again, for the reasons I stated earlier, to ensure that we roll this bill to third reading, I'll withdraw the amendment at this time, but look forward to having this discussion again when we do the licensure bill. Thank you, Mr. President.
Show the amendment withdrawn without objection. Read the next amendment.
Late filed barcode 876992 by Senator Farmer. Between lines 667 and 668, insert amendment.
Late file amendment requires 2/3 for introduction. Show it introduced without objection. Senator of the 34th, Senator Farmer, you recognize.
Thank you once again, Mr. President. And again, looking to eliminate any discriminatory effects of people utilizing this new legal medical treatment. I was shocked to learn that some patients who are on transplant lists for kidney or other organs are being dropped from the list simply because they are shown as a licensed card holder under the database. It's one thing if maybe you're talking about a lung transfer and smoking of an item would impact the viability of that organ, but patients should not be discriminated against who need a kidney or some other transplant simply because, again, they are exercising a legal medical option. And so, again, this is an important issue to make sure that people who exercise this option are not discriminated against, especially here where their very life may be at stake. For the reasons stated earlier, Mr. President, I will again withdraw this amendment, but again, look forward to working with sponsor down the road on this important issue. Thank you.
Show the amendment withdrawn without objection. Read the next amendment.
No further amendments to the amendment, Mr. President.
Senators, we are back on the delete everything amendment by Senator Brandis. Are there questions of the sponsor? Questions of the sponsor. Senator of the 37th, Senator Rodriguez, you recognized for a question.
Mr. President, thank you. This applies to the amendment and obviously the bill prior to and as amended. And we probably can't avoid litigation, but one of the areas where it seems that we're out of step with the Constitution I wanted to ask you about, and that is with respect to the use of the different standard applied to patients when they have terminal versus debilitating conditions. Could you explain a little bit why that is being done?
Senator Brandis, you're recognized.
And you're speaking specifically to those individuals under the age of 18, correct?
Senator Rodriguez, you're recognized.
Thank you. I am not, my understanding, so there are, with respect to some of the steps that patients need to go to, there are different standards for persons with terminal conditions, that are non-terminal, I guess, debilitating conditions that are non-terminal versus those with terminal. But then there are even more steps when we're talking about minors, as I'm reading the bill. I mean, I'm not going to go through them. I'm just trying to zero in on the fact that, not to belabor the point, but obviously a terminal condition is one that's likely to lead to death. And that's very different from a debilitating condition, which is one that relates to a significant interference with the ability to go through daily life. And the constitutional amendment and the Constitution mention some of those debilitating conditions like PTSD, glaucoma. I'm not a physician, but I don't think those are terminal. And so it gives us some context in addition to saying that this medicine.
Senator Rodriguez,
yeah,
you might want to save that for debate.
Right. No, but I'm trying to crystallize the questions. I'm not trying to go through the different steps in there. I'm just trying to get at the difference between terminal and debilitating and why there are more hoops if the condition is not terminal.
Senator Brandes.
Thank you, Mr. President. As it relates to terminal and it really deals with individuals under the age of 18. As we're trying to hone in and say they have access to all the other forms of medical cannabis, but under 18 they have to have 2 physicians and they must be shown to be in a terminal condition. And one of those physicians has to be a board-certified pediatrician. So that's really where we focus in on the word terminal condition as it relates to those individuals under the age of 18.
Senator Rodriguez, you're recognized.
Thank you. So my question is just why do we make that distinction for minors?
Senator Brandes.
So in my discussions with physicians and my discussions with the House and a variety of other sources, we are looking at and making sure that individuals who use medical cannabis under the age of 18, they currently have to have 2 physicians. That's what the current law is. And we allow them access to vaping. We allow them access to tinctures, oils, all of those they have access to today. Specifically, as we're trying to address it, is just smoking, right? Just smoking medical cannabis and whole flower smoking. And so we thought that there was, the physicians I talked to did not believe that they would ever provide that. And then in our negotiations with the House, we settled on this, which is essentially the right to try language that Florida had adopted a few years ago. So we think that they may potentially have been covered under the right to try law as it stands. We thought that the appropriate way to handle that was to put for those individuals under the age of 18 to specifically spell out those provisions that we include in right to try. The only major change we have here is that it requires a board-certified pediatrician to be one of the physicians that certify it.
Further questions? Further questions? Senator Harrell, you're recognized for a question.
Thank you, Mr. President. I so appreciate the opportunity. I have several questions. The first of all deals with the ability, the 35-day supply in the form of smoking and the extension of that to being able to receive 6 individual 35-day supply allotments, basically. And currently in statute, if that a patient can, for regular marijuana, if they ask for an additional extension of that, you can appeal to the Board of Health, the Department of Health, to get an extension for more than the supply that's allowed in statute. Would that apply also, the same language apply also to smoking marijuana?
Senator Brandes.
If I understand the question correctly, you're asking about the 6 times that they can go, the 6 35-day periods. And what we do, that just conforms to what the standard is for all the other types of marijuana today. So if you go to a physician, you have essentially 6 35-day periods that you can go before you have to go back to the physician. That was what the standard was for all other forms of medical cannabis. We thought it was appropriate, if we're just adding full flower, to make that the standard for this as well. So that stays the standard across the board. We don't want to make it more expensive and have any individuals have to go back to their physician once a month, essentially, in order to get full flower cannabis.
Senator Harrell, you're recognized.
Thank you, Mr. President. In a way of follow-up of that, if the individual feels that they need more than that 6-month supply, basically, they can appeal to the Department of Health. And if the Department of Health does not answer that appeal within 14 days, it's automatically approved. So would that extend then to the smoking of pot, and could you also get that for, say, 2 years? Could that extension extend for 2 years or 3 years?
Senator Brandes.
Thank you. And to my knowledge, it's not an extension to go back to the physician. It's extension on amounts. So we allow individuals to possess up to 2.5 ounces of full flower, but for some individuals, they may use more than that for their medical condition, specifically if they have, Lou Gehrig's disease or other type of conditions that would qualify, and their physician then would have a process to go to the Department of Health and seek more medical cannabis. This is exactly the same process that we do in all of the other areas of cannabis. So if it's an oil or if it's a vapor, they can go and apply to those physicians. So this just lays out that same process.
Senator Harrell, you're recognized.
Thank you very much. And on line 659 through 665, it discusses smoking marijuana in a nursing home. And can you clarify for me what a nursing home would have to do if they chose not to allow that in their nursing home?
Senator Brandes.
Thank you. There's this interesting subject to talk about, because if they take federal funds, they may be federally prohibited from allowing smoking cannabis. But our bill simply allows it at the state level if the policy of the nursing home is to allow it. So they must adopt a policy, and if they adopt that policy, if they're in a nursing home, they're in a hospice, or they're in an ALF, then they can. It allows those facilities to allow individuals to utilize medical cannabis on their facilities.
Senator Harrell, you're recognized.
Thank you very much, Mr. President. A large number of our individuals in nursing homes are paid for under Medicaid. Would that then require every nursing home that accepts Medicaid to establish a policy to allow it if they chose to, and would that put them in jeopardy?
Senator Brandes.
Thank you, Mr. President. Nothing requires that a nursing home, an ALF, or a hospice adopt a policy. They can adopt a policy to ban medical cannabis. They can adopt a policy to allow medical cannabis. But it's really to make sure that the state doesn't prohibit them from adopting a policy as it relates to medical cannabis on their property.
Senator Harrell.
And do you have it? Thank you very much, Mr. President. Would that put them in danger if they adopted a policy to allow smoking of marijuana in their facility? Would that put them in danger of losing federal funds through Medicaid?
Senator Brandes.
Thank you, Senator Harrell. As you know, I'm not an attorney, I'm a Christian. And so I can't answer those types of a question that specifically is of a legal nature like that. I would simply state that that really it's a legal question that they need to work through with their attorneys as they're adopting a policy of this nature.
Senator Harrell, you're recognized.
Yes, and I'd like a little more information on how we're setting up the new consortium. It had previously been, there had been a coalition, and it was housed in the in Moffitt Cancer Center. Can you give me some additional information on exactly what board is going to determine what universities are to participate in the consortium, and also where the funds, the $1.5 million that we're going to allow for research to go into, to what university would that go?
Senator Brandes, recognized.
Thank you, Mr. President. It will all go to the Board of Governors, and the Board of Governors will establish the universities that can participate in the consortium, and the Board of Governors will allocate the funds.
Senator Harrell, you're recognized.
As we go forward with the research, which I think is absolutely essential, are we going to require that part of that research also gather information as to what the conditions are that were required for smoking medical marijuana? Are we going to make sure we know that an individual is smoking? What conditions were necessary to precipitate the use of smoking medical marijuana? And also the outcomes that are that we can see 6 months, 9 months, a year later. Are they going to be tracking that as well?
Senator Brandes.
Thank you, Mr. President. If you go to page 6 of the amendment, line 137 starts with what a physician has to provide to the department. And part of what they have to provide is the research around this. So every time they're writing a recommendation, they need to provide the research and the reasoning for why they're doing this. We do this today with all other conditions as it relates to medical cannabis. So if they fall into that category, they have to provide the research that goes along with that. We're also saying now that if they have to do that if it's smoking as well.
Senator Harrell, you're recognized.
Yes, to follow up on that, are you going to be requiring that they also report improvements or deterioration in condition as a result of smoking marijuana?
Senator Brandes.
Thank you. Again, they're going to go back every essentially 210 days. They're going to go back to the physicians, and the physician has to re-up that. And so I would imagine that will be in the new report that they issue every time they go back to the physician.
Senator Harrell, you're recognized.
Outcomes usually are measured very differently than a diagnosis code. And normally, presumably, they would be doing a diagnosis code as part of the form that they fill out for this. Is there any specific requirement that they report outcomes? Was there improvement? Was there deterioration in the specific condition for which they were ordered the medical marijuana?
Senator Brandes.
Thank you, Mr. President. We make them provide a number of things. We make them provide a list of other routes of administrations, if any, that the certified by a qualified physician that the patient has tried, the length of time the patient has used such routes of administration, an assessment of the effectiveness of those routes of administration in treating the qualified patient's qualified condition, any research documenting the effectiveness of smoking as a route of administration to treat similarly situated patients. We have a statement signed by the physician and showing that their opinion that the benefits of smoking medical cannabis continue to outweigh the risks for a qualified patient. That's what we require.
Senator Harrell. Okay, before we move further in questions to the senator from the 18th, Senator Cruz, I'm going to recognize the senator from the 31st, Senator Berman. You have a recognition, I understand.
Thank you, Mr. Speaker. Oh, Mr. President, excuse me. I would like to recognize the mayor of Delray Beach, Shelley Petrolia, who is from my town, and welcome.
Welcome to the Florida Senate. Okay, further in questions. The senator from the 18th, Senator Cruz, you're recognized.
Thank you, Mr. President, and Senator Brandes, thank you for getting this bill in proper posture and order. You know that I voted for it once before, and I intend to vote for it again, but I do have questions, and it speaks to the appropriation, because as I looked at the appropriations, I noticed that there's $1.5 million in recurring general revenue to the Board of Governors to implement the consortium. And then I saw another $705,000 in recurring trust fund money to implement the requirements of the Act. And my question to you is that I'm sure that we are collecting fees on all of this implementation. And my question is, why are we assigning this a recurring general revenue allocation when it should be coming out of the fees?
Senator Brandes.
Thank you, Mr. President. And as you pointed out, there is some money coming out of the fees, some money coming from the trust fund. But I think the $1.5 million in general revenue and recurring shows Florida's commitment to research. That's really what this is all about. It's all about, we're focused on research, and I think it shows that Florida is willing to invest through the Board of Governors, through our great state universities in research. I think it actually highlights the commitment that Florida is willing to make, that all Floridians may benefit by additional research, and that's why we're taking it out of GR.
Senator Cruz, you're recognized.
New question,
yes.
Mr. President. I had a constituent that came in today, and so I feel compelled to ask this question. And the question was on the prescription limit for the medical marijuana at 2.5 ounces every 35 days. Their concern was that that was an excessive amount, and I think they said that it was more than Cheech and Chong could smoke in 35 days. So could you speak to the amount that is allocated?
Senator Brandes.
Thank you, Mr. President. And if you look around the country, this puts us basically in the middle of where the other states are as it relates to medical cannabis. So I think as we looked at the research, as we've talked to individuals, we've talked to different physicians that relate to this, there are some conditions that will require much less. There were some conditions that may require more, and we wanted to make sure that we provided a pathway for individuals who need more. But I've talked to people just this month who today in Florida use about 4 ounces a month because of, and are legally allowed to use 4 ounces a month because they use it, they take that whole flour and they grind it up and use it in oils and use it in edibles for their conditions. But specifically people with ALS and other debilitating conditions may be high users, and so we thought that the amount should be appropriate, but also have it for about 90% of patients. We think 2.5 ounces will be enough, but there's also a pathway for more.
Senator Cruz, you're recognized.
Thank you, Mr. President. So am I right to assume that the doctor will make the determination on the ounces that will be prescribed monthly?
Senator Brandis.
Doctor will make a recommendation for the amount. That's correct.
Further questions? Senator of the 33rd, Senator Thurston, you're recognized.
Thank you, Mr. President, and I thank you for bringing this legislation. As an attorney and a Christian, I had a few questions for you. I noticed that a lot of the provisions have to do with minors under the age of 18. Do we know what percentage of the patients will be minors or are minors now in the numbers?
Senator Brandis.
I don't have any of the current numbers about how many minors are using. I'm sure we can ask the Department of Health to provide those.
And just lastly, I know you were answering Senator from the 37 questions about terminal and different conditions. And I was just wondering, if a patient is not terminal, there's no minor again, there's no way for that patient to ever have the use of smokable marijuana. Is that what we're saying?
Senator Brandis.
Under this bill, that's correct. The provisions here are they have to have a terminal diagnosis and they have to have 2 physicians, one being a board-certified pediatrician.
Further questions? Senator of the 31st, Senator Berman.
Thank you, Mr. President. Senator Brandis, thank you for bringing this bill, and I just have a question about when you can get your refills on the 35-day supply. I'm concerned because I know with other pharmaceuticals you can often get them before the end so that you're not in a position where the 36th day comes and you don't have your supply. And also when you go on a vacation, often you're obviously it would have to be in the state of Florida, but you can get a vacation refill. So is there anything contemplated in this bill that you can get it prior to the end of the 35th day, or you have to wait to the 35th day?
Senator Brandis.
Thank you, Mr. President. No, you would have to wait to the end of the 35th day. Now, we allow you to possess up to 4 ounces. So if you had some left over from a previous month, you could continue to possess those and get to the max amount of 2.5 ounces. We wanted to make sure we left enough space in there for individuals. But we expect people to be using this, and we think that ability provides enough access for individuals.
Further questions? Further questions? President Lee from the 20th District, you're recognized for a question.
Thank you, Mr. President. And I have only a rudimentary understanding of this subject matter. I have not been involved in any of it, Senator Brandis, so I apologize for what may seem to be some pretty elementary questions here. But I think at a minimum, Mr. President, it's important to get them on the record, maybe not even for this bill, but for what lies ahead. There's been reference to the Constitution and how we're in conflict with the Constitution. I think the courts have found we're in conflict with the Constitution. I saw on page 2, one small reference in section 6 to making provisions in public places for smoking medical marijuana. Is there any other, we've gotten into a stage where we, much like we see every election cycle for candidates, we sign petitions to go to the polls that says one thing, and then we run a campaign that says another.
And the public thinks they voted for the campaign, when in fact what they really voted for was the petition. So can you help, for the record, the public understand how this bill meshes with the petition itself, why this bill is necessary pursuant to the petition that was signed by the voters and therefore what was placed in the Constitution?
Senator Brandis.
Thank you, Mr. President. And Senator Lee, before, let me look for my notes here, but understand, don't worry about the elementary nature of this, of your questions, because most people haven't studied medical, or most people in this room haven't studied medical cannabis since college. So what the judge said, and that's who's actually reviewed the constitutional petition, she said that qualifying patients have the right to use the form of medical marijuana for treatment of their debilitating medical conditions as recommended by their certified physicians, including the use of smokable marijuana in private places. And so I think as we look, the judge went through the petition, she went as the challenge, and that was her order.
President Lee.
Okay. As it relates to liability, I didn't, this is considered medicine now because we put it in statute. The FDA doesn't consider it medicine. And yet physicians are going to be empowered with the ability to write prescriptions for medical marijuana, smokable marijuana. Are there any limitations of liability for physicians who are now put in the position to have to issue prescriptions for something that hasn't been approved by the FDA, and therefore they don't have the cover of the approval process, that's rigorous approval process that's typically been put in place for drugs in America?
Senator Brandis.
Thank you, Mr. President. They're covered by the Constitution. So the Constitution provided liability protection for physicians who recommended medical cannabis.
President Lee.
That's good. So what is that? Is that a simple answer or is it a complicated answer?
Senator Brandis.
Well, I don't have the constitutional language here specifically in front of me, but I believe that the Constitution provides civil liability protection for physicians who in good faith recommend medical cannabis.
President Lee.
Thank you, Mr. President. In terms of
Senator Brandis, further response. Our crack staff has come into my aid, and the current statute says a physician shall not be subject to criminal or civil liability or sanctions under Florida law solely for issuing a physician certification with reasonable care to a person diagnosed with a debilitating medical condition in compliance with this section. So we have statutory protections for those physicians as well.
President Lee.
Thank you, Senator Brandis. That's very helpful. In terms of Medicaid, there's been some discussion about it. There's no requirement that this be provided under Medicaid. Is that correct?
Senator Brandis.
Thank you, Mr. President. No, there's no requirement for any health care companies to provide this. In fact, this is largely a cash business.
President Lee.
Thank you, Mr. President. How about in terms of, has anyone contemplated the effects that smokable marijuana might have on the Medicaid program as people develop other symptoms and conditions relating to smoking or the use of cannabis for that matter, and may well end up with a condition that lands them in the Medicaid program? Has there been any conversation about that?
Senator Brandis.
Thank you, Mr. President. There has not been any conversation about that. The upside is we have $1.5 million every year that we're going to be doing on research to continue to look at that, and also looking at with medical nursing homes and the aging population. We expect a lot of research to come out of that as well.
President Lee.
What I hope, Mr. President, will be one final question. In terms of liability for the consumer of medical marijuana, driving under the influence, our drug-free workplace or employer liability issues for people that may come to work in some form of impairment. How is all of that going to work? Is there anybody thought through that yet?
Senator Brandes.
Thank you, Mr. President. Well, part of that is employer-specific. Obviously, if they're a drug-free workplace, they would have to potentially have an exception to the policy for someone who has medical cannabis. This bill provides individuals to prohibit medical cannabis or smoking of medical cannabis on their private property. So they would be able to have people be prohibited. And then it also says that you can't smoke in a public place. So you can only smoke in a private place. We would think of that as someone's home, someone's medical setting, if that's allowed by their medical setting.
President Lee.
Thank you, Mr. President. I guess one final question. I honestly don't anticipate, although you've done wonderfully with these questions, I don't really anticipate everyone have thought through all of the intended and unintended consequences of this brand new public policy. But in a circumstance where someone is operating heavy machinery in a construction setting and you know, they haven't smoked on premises, but they're clearly under the influence, they shouldn't be on heavy machinery, and they're at work, is their employer going to have any liability associated with that, since they have no control over whether or not the employee is able to use this new drug?
Senator Brandes.
Thank you, Mr. President. Again, it comes back to the specific policy of the employer. So if they have a drug-free workforce policy, if they do drug testing, it really is dependent upon the policy of each employer and, frankly, their insurance company as to the liability and whether they're conforming to the provisions of that policy.
President Lee.
I'm sorry. So maybe this is the best way to ask it. So who's in control? If I'm the employer and I want to have a policy that says people can't be impaired during their work hours, do I have control over that policy, or does the right to medical marijuana under this prescription program drive? What's in control?
Senator Brandes.
So I think you have control of the policies of employment for your employees and how they're, you know, what they're allowed to do, whether they're allowed to handle heavy machinery or other types of devices. So ultimately, I believe it would be an employer policy as it relates to this, and you would be in control of that policy.
Further questions? Further questions? Senator of the 22nd, Senator Stargell, you recognized.
Thank you, Mr. President. And my question is very simple, Senator Brandes. We're here today for this discussion. You briefly touched on the lawsuit that happened, and then the governor decided he wasn't going to appeal. So let's say that that's the case, and the governor, and we don't pass anything today, and this bill were to fail. What would be the state of regulation around the smokable marijuana as the courts have stated?
Senator Brandes.
Thank you, Mr. President. I think it would go back to current law, and that we would allow MMTCs to sell full flower with essentially no caps on limits to what they could sell. So it would go back to that standard, and there would be some question of whether they could smoke in a public place. That would be also a question that would be debated. There would be some question of whether people could not allow them to smoke on their private properties. I think that would be a question. If this was not to pass, obviously there would be no research component if this was not to pass, and the court's court's finding would stand.
Senator Stargell.
Thank you, Mr. President. And so all of those decisions, and I think even whether a person could smoke it under 18, all of that, all of those things then, with the absence of us passing any legislation, would be decided through our court system via a variety of multiple lawsuits? Is that what would happen?
Senator Brandes.
No, I don't think they would be decided. They may be decided that way, but largely, unless somebody was impacted, they wouldn't be decided. That would be the law. Anyone under the 18 would be allowed to smoke medical cannabis if this was not to pass. But in any of the other provisions that you discussed would be allowed unless a city or some other municipality took some authority on that.
Senator of the 29th, Senator Rader, you're recognized.
Thank you, Mr. President, and thank you, the Senator from the 24th, for all the work you've done on this in short order. I got a few questions, and I think you've spoken a little bit about patients under age 18 The bill limits smoking medical marijuana for minors up to a patient under age 18 who must be diagnosed with a terminal condition, and a qualified physician must certify that smoking is the most effective means of administration for the patient. Why do you need the concurrence from a board-certified pediatrician also needed?
Senator Brandes.
Thank you, Mr. President. The Florida Right to Try Act has 2 physicians to sign off on experimental medication. And so we use that framework and recognizing that they were under 18 and thinking about who we would want to be that second physician to be. We thought that these individuals would be seeing somebody who was a pediatrician likely, and that pediatrician should be of the highest caliber, and the board certification is certainly pediatricians of the highest caliber, or at least the best way for us to be able to provide that. So that's why we set that standard. It really does rhyme with the Florida Right to Try Act.
Senator Rader.
Thank you, Mr. President, and thank you, Senator. Do you think that might add more financial burdens on families who are dealing with their child's terminal condition by having to get that second opinion?
Senator Brandes.
Thank you, Mr. President. I think if we're talking about 10 or 12-year-olds smoking medical cannabis at the end of their life, these individuals are seeing quite a few physicians today anyway. We would imagine that they're already seeing a a pediatrician as well, and I don't believe that will add financial burden for those individuals, because clearly they're seeing a lot of physicians at that point of their life.
Senator Rader.
Thank you, Mr. President. We've heard from patients and advocates that after paying out of pocket for the doctor's visit to get qualified and paying for the medical marijuana ID cards, some patients can't afford to buy the medication. Does anything in this bill address the cost of the medication or financial assistance for patients?
Senator Brandes.
Nothing in this bill addresses that issue, but my hope is that as we address the regulatory structure and follow-on bills, that we will begin to look at that. I think, as you heard testimony the other day, that we've got licenses selling for $80 million to out-of-state companies that are from California or Colorado or Canada or Massachusetts, and they're recouping that cost of that license on the backs of patients. And I think we can address the licensure structure, and that will help drive down cost over time.
Senator Rader, you're recognized.
Thank you, Mr. President. Have you thought about doing any kind of late filed amendment on that issue that you just brought up? You had a whole bunch of other amendments. Would you take up a late filed amendment on third reading on that issue?
Senator Brandes.
I think that's probably something that needs a deeper discussion and to be vetted through the entire process. If we're going to change the entire licensing structure, it probably would not be appropriate for a third reading amendment.
Senator Rader, you recognized.
Thank you, Mr. President. Senator from the 24th District, I was the alternating chair for JAPSI for over the last couple of years, and we had a really big issue with the Office of Medical Marijuana Use, how they ignored letters from our committee and our committee staff. Is there anything in this bill that addresses the issues that were in that vein, that the executive branch just completely disregarded what we, the legislature, asked them to do?
Senator Brandes, let's keep it to questions.
Thank you, Mr. President. No, nothing in this bill specifically addresses that. I'm encouraged, though, that we have a new governor, a new administration, a new vision for where he wants to take medical cannabis, and that one of his first decisions as governor was to withdraw from this lawsuit, or to in the middle of March, and to allow the legislature to do its job. So I think as we're providing oversight, as we're doing this, I think you have a new administration, a new vision for where that office needs to go, and I think hopefully we'll see some renewed activity from them to implement the law as we designed it.
Senator Rader.
Thank you, Mr. President. I think this is my last line of questioning, which is when you introduced the bill before you put on the amendment, you talked about a little bit of the history, how this came about, but you started, I think, not really at the beginning. You started at the point of the constitutional amendment in November 2016. This really kind of began a few years before that, because part of my debate, it might be in just a few minutes, because we might be rolling this and I have not had time to research it. Do you know the history of before I mean, there was a constitutional amendment either 2 years, 4 years before that. We had something with terminally ill children. There was a certain phrase for it. I can't remember the phrase off the top of my head. Is there, could you describe the history before, because this has been going on for 5, 6, 7 years now, the total history of medical marijuana in the state of Florida?
Senator Brandes.
That's a little bit outside the scope of the legislation, but I will, a few years ago, Senator Bradley, myself, Senator Bean, and then Representative Matt Gaetz began to work on low CBD, or high CBD, low THC medical cannabis law, and established that a number of years ago. And from that, we find that that has kind of grown. And then obviously there was the constitutional amendment in 2016 and us implementing that in 2017. All of those things, that's really how this began to play out. But I would say it started with the four, myself, Senator Bean, Senator Bradley, and Representative Gaetz, that began this journey of talking about medical cannabis.
Further questions? Further questions? Senator Stewart.
Thank you, Mr. President. I just have a question regarding the physicians that certify the 30-day supply not to exceed 2.5 ounces. Is there a requirement that says that they have to go some place, or they can't go to the street and just buy whatever amount of marijuana they want because they got certified to have it?
Senator Brandes.
Thank you, Mr. President. Once you receive your MMT, your medical cannabis card, you must purchase your medical cannabis from a licensed medical marijuana treatment center. That's a requirement of the statute. For it to be legal medical cannabis, it must be purchased from a dispensary that's licensed.
Senator Stewart, from the 13th, you recognize.
I just am curious because I don't know how you would distinguish that you got it from the medical place that we want you to go to versus some street.
Senator Brandes.
Thank you, Mr. President. We have labeling requirements and bottling requirements as part of this legislation. So we require it to be labeled and purchased in a specific manner.
Further questions? Further questions? Chair Harrell, you had an additional question? Okay, you're recognized.
Thank you so much, Mr. President, for giving me a second bite at the apple. I do appreciate it.
Small bite.
Small bite. A small bite. Okay. I'd like further information about the ability of the Board of Medicine and the Board of Osteopathic Medicine to establish rules by July 1st, 2021 for the practice standards under which certification for smoking could be used. Can you give me some indication, presumably, once these rules are established, will physicians then have to meet certain standards and conditions as established by those rules? And if so, what ability would the Board of Medicine have to censure a physician who perhaps exceeded those rules?
Senator Brandes.
Thank you, Mr. President. As you know, better than most here, being a physician is both an art and a science. And there is some latitude we give physicians to try new drugs, to try experimentation, because we don't know the solution to many of the challenging healthcare problems that we face. And that's how we build on this body of research. And so while we will have standards, many physicians will be departing from those standards when they deem it appropriate, but because they are the experts in the room dealing with patients with very challenging issues.
Senator Harrell, recognized for a question.
What I'm hearing you say, and correct me if I'm wrong, that the Board of Medicine and Board of Osteopathic Medicine will establish standards, but in reality, they'll have no impact. A physician may do basically whatever they choose to do in certifying someone for smoking medical marijuana.
Senator Brandes.
Thank you, Mr. President. As with most physicians, as you know, they typically will follow the standard. There's some type of standard process, some standard protocols, some standard treatment options for individuals. But there are occasions where they depart from that standard when they deem it appropriate. And I think that's what this will allow. If that standard may not be appropriate for that individual, they will be allowed to depart from that standard.
Senator Harrell, final question.
No question. Thank you very much, Mr. President. And at that point, they would certainly be, the Board of Medicine and Board of Osteopathic Medicine would have the ability to bring them before the board to address a specific, perhaps, breach of what that standard would be. Is that your understanding of what would happen?
Senator Brandes.
Thank you, Mr. President. As we've discussed earlier in questions, there's a specific requirements that they provide information every time they certify that patient for smoking. And so as that data comes in, as these boards and the Department of Health reviews that, if there are extreme outliers that they need to investigate, they have that authority under current law.
Further questions? Further questions? Leader Gibson, you're recognized for a question.
Thank you, Mr. President. And I just have two. One has to deal with the demographics, and I asked for this in the committee. I don't know if you have the information of the doctors who are the qualified, I guess, marijuana doctors. I think I heard a number of like somewhere between 5,000 and 7,000 that are participating. But what's the demographic of that group?
Senator Brandes.
Thank you, Mr. President. I don't have that information, but I'm happy to follow up with the Department of Health on the demographic breakdown of the physicians.
Leader Gibson, you recognize.
Thank you, Mr. President. And in terms of participation in the vertical process, to even be able to participate in the production and sale of the medical marijuana, are there any African American professionals participating in that?
Senator Brandes.
I'm sure there are African Americans participating either as employees or as growers or as, but I don't, again, have the demographic breakdown of the license holders.
Leader Gibson.
Thank you, Mr. President.
Thank you. Further questions? Further questions? Okay, Senators, we are on the delete all amendment as amended. Leader Gibson has agreed on behalf of her caucus to roll this bill to third. We can have debate on the delete all. We can go ahead and call the vote and then move to third where there will be opportunity for debate. So is there any debate on the delete all before we call the question? Seeing no debate, all those in favor of adopting the delete everything amendment signify by saying yay. Opposed, nay. Show it adopted. The Senator of the 24th District, Senator Brandes, moves that the bill be read the third time by the required 2/3 vote. Is there objection? Seeing no objection, show the motion adopted. Read the bill.
Committee substitute for committee substitute for committee substitute for Senate Bill 182, a bill to be entitled An Act Relating to the Medical Use of Marijuana.
Is there debate on the bill as amended? Chair Bradley, you are recognized.
Thank you, Mr. President. Senators, when we passed Senate Bill 8A 2 years ago and included in it a restriction on smoking medical marijuana, that was done with good reason, and it was done in good faith. We had listened to medical professionals, and we did what we thought was right for the health of the people of the state of Florida. But like many of us, I've come to the conclusion that when it comes to the smoking issue, I believe it's time to move on. I think it's time to move this discussion from Tallahassee to doctors' offices around the state of Florida. And I'm glad before we do that, that Senator Brandes, with his good work, has put appropriate guide rails and reasonable guide rails before we move it from Tallahassee to the doctors' offices around the state of Florida. Because keep in mind, as Senator Stargell pointed out in her questioning and Senator Brandes' answers, that if we did nothing and Judge Geaver's order was allowed to stand, there would be no guide rails. And that, I think, would not be in the best interest of the people of the state of Florida. But I do want to have a quick discussion through the Florida channel to the physicians of the people, the physicians throughout the state of Florida, and that is this. I want to challenge them because it's in your hands now. When you meet with your patients, be serious about this. Be serious about the health of your patients. This is a medicine under their Constitution. Treat it as such. And make sure when you make your decisions with your patients that you do so in their health and in their best interest and not turn this into some kind of joke. I'm particularly happy that this includes a commitment to research. We started that process together with Senate Bill 8A, but this takes it to the next step. Because the fact of the matter is, when you get past all the rhetoric, we don't know nearly enough about what dosages work, what will help, what won't help patients. And we are talking about some of the sickest people amongst us in our society. And we have a duty, and our physicians have a duty, to do what's right for them and to make them better. And so I just want to leave thanking Senator to sit down, but before I do, thank Senator Brandes for his good work on this and to urge the physicians around the state of Florida to take seriously their oath to do no harm.
Senator Harrell, recognized in debate.
Thank you very much, Mr. President. I appreciate the ability to debate the issues. And first of all, I want to compliment Senator Brandes on his keen mind and his ability to debate and articulate this issue very succinctly. I appreciate your sincere efforts in what you're doing. The fact that we're here today is very disappointing to me. The fact that the judiciary has decided to step into something that I think was very clear in the constitutional amendment that was passed, and to have made this decision, and quite unfortunately, we now are in a position to have to write legislation to implement what I believe was certainly not the intent of the voters, to allow smoking of marijuana. I believe that this bill has some faults in it, but I think it's a step. It's probably the best we can do at this point. I too want to caution our physicians as they move forward. As they look at each individual patient, they evaluate that patient, and they determine that it is for me, the only appropriate way in which to administer what now has been constitutionally deemed a medication. To me, it's very important that the Board of Medicine take their responsibility very, very succinctly and very carefully to determine those practice standards. This is the key to it. What should be the standard of care that a physician has to abide by in order to order, never prescribe, because prescribing an illegal substance, a Scheduled I substance, is not allowed under DEA rules. So they will be ordering or certifying an order for marijuana and for smoking marijuana. The Board of Medicine needs to be extremely cautious in how they write that standard of care, and so that physicians will know what that standard of care is. And the Board of Medicine and the Board of Osteopathic Medicine should stand by their ability to discipline a physician who exceeds that standard of care. I think the research component and the component that deals really with doing that analysis of the data that we will be receiving, specifically about the conditions for which one is ordered to smoke, given a certificate to smoke marijuana, and also to evaluate those outcomes. That will be very difficult. I think we may have to come back at some point and look and require that we also get detailed information, given our electronic medical records and we do have the ability to do that. And we can do it in a de-identified way to protect the patient. But we need to know, and truly if we're going to do research, we need to have that detailed analytical look at what the conditions are, what the outcomes are for which we are prescribing medical smokable marijuana. I think this is probably the best we can get at this point, but and I will vote for the bill at this time, but I think there are many more steps that need to be taken in order that we take seriously that Hippocratic oath, and we as a legislature have the same responsibility that physicians have. Do no harm.
Further in debate. Further in debate. Senator Rodriguez from the 37th, you recognized.
Thank you, Mr. President. Thank you for your good work on this. I'm happy that this legislation is moving forward. Obviously, our duty here is to implement the Constitution. We haven't completely done that. The Constitution clearly contemplates smokable form of medical marijuana when it's necessary. I think that the one thing that I would point out that seems to remain a problem is an arbitrary distinction between persons with different types of illnesses. The Constitution is about what the access to this medicine in the Constitution is for persons with debilitating medical illnesses. Now, I stand corrected. I was confusing different sections of the law earlier. The distinction is only for minors, and specifically it's in situations where, again, a doctor has said that the smokable form of medical marijuana would be the best way to receive the medicine. And we're limiting it only to those minors with terminal illnesses, whereas the Constitution grants access to patients with debilitating medical illnesses, and it specifically lists out many of those. So I'm just zeroing in on that. It is a little bit of a very specific case. I don't think it's going to come up very often, but there are, in my view, minors who will fall into that category, who have constitutional rights that I don't think we're meeting with this bill. But happy to vote for the legislation because it goes a lot further than current law in implementing the Constitution. And I want to thank you for your work on this, and we'll be voting yes. Thank you.
Further in debate. Senator from the 34th, Senator Farmer.
Thank you, Mr. President. First, thank you, Senator Brandes, for bringing this forward. This is a great day in Florida. We are honoring the will of 72% of Floridians who voted to allow marijuana as a medical treatment option. And those voters absolutely decided that smoking marijuana should be an option. I want to read to you language from the text, just so that there is no question about this. Nothing in this section shall require any accommodation of any on-site medical use or marijuana in correctional institution or detention facility or place of education or employment, comma, or of smoking medical marijuana in any public place. Clearly, that language implies that smoking of marijuana in a private place shall be allowed. And so by our action here today, we uphold the good decision by Judge Gievers, and we recognize that this is a patient-doctor choice. For some patients, an oil, some other form of medical marijuana may be the best treatment option, but for some patients, smoking will give them the most relief. It's most effective, and that should be between them and their doctor. And this is going to sound like budget suck-up language, but every time I think my respect for Senator Bradley has reached its zenith, he takes it up another notch. Because what you just said, medicine is medicine. And marijuana is now medicine in the state of Florida. And how that medicine is administered should be between that doctor and that patient. And by this good legislation, that's what we're doing. So thank you, Senator Brandes. Thank you, members. Let's pass this and let's move Florida forward. Thank you.
Further debate. Senator of the 29th, Senator Rader, you're recognized.
Thank you, Mr. President, and thank you, Senator from District 24, for your hard work in getting this done. I know that it's a lot to take in, and we've been discussing these issues for many years, but at the end of the day, it is medicine, and it's medicine that's going to be used for a lot of people who need it. My mom is not terminally ill, but she lives in Israel and takes medical marijuana. and it's the greatest form of medicine that she takes to relieve her pain. And I've had to roll joints for her. Haven't never done that before, but my brother-in-law showed me how to do it. And stop laughing. And it's a very important thing. I know we kind of take light of it here, or we overanalyze it here. But at the end of the day, there's going to be thousands and thousands, probably into the millions. I've heard 21 million people. There's going to be millions of people who are needing this type of remedy. The thing that I wanted, and again, we had short time to prepare, only because of the of rolling this bill so fast. I know that Representative Katie Edwards and former I guess it's Katie Edwards Walpole and former Senator Jeff Clemens were instrumental in pushing this. And very specifically, Katie gave me a few texts because I called her in the new pods in the back room. So thank you, Mr. President. I think that's a great idea what we're doing back there. So I'd be remiss if I didn't recognize their work. And they filed the 2013 Kathy Jordan Medical Cannabis Act. So we've been talking about this issue for well over 6 years. And she also said, many of you know that Congressman Gates has acknowledged on many occasions how annoyingly persistent that Rep. Edwards was in pushing the issue and encouraging bipartisan dialogue. And she wanted to let everybody know that she's at home watching and expecting her baby boy this summer. But this has been a bipartisan effort over many years to do the right thing. And thank goodness the voters in the state of Florida at 72%, which is an enormous edict for us to follow. I always joke, if you put your name on the ballot and you're one-on-one with someone, you're going to get a third of the vote no matter what. So when you get 72%, that's a landslide, a statewide ballot. And I believe almost every district, if not every district, passed this. And so I'm happy to report back to my constituents that we're passing it out of the Senate. Hopefully the House will follow, and I know the governor in his leadership will enact this into law. Thank you, Mr. President, for making it a priority of yours and getting this done the first week.
Further in debate. Further in debate. Senator Brandes. Oh, hold on, Senator Brandes. Senator of the 12th, Senator Baxley, you want to debate? You're recognized.
Thank you, Mr. President. This has been a long discussion in the legislature. When this first got cranked up, I was still in the House chairing Judiciary. That's been a while. My concern, I have never voted for one of these bills that would expand the use of marijuana, simply because it's such a broad landscape. But I want to thank a number of you who have devoted many, many hours to trying to carry out our responsibility to abide by the Constitution and implement it. And still, with abundance of caution, I've tapped the brakes several times because I'm saying we got to be careful. This could go all wrong. But there has been a lot of work done here. And today, this will be the first time on the House of the Legislature that I voted for a marijuana bill, because I believe you touched something very important with the room that we had left, given the transpiring of what's happened in the courts and in the governor's office and in many venues that led to the day we are standing at today. You have protected children. And I appreciate that flexibility. I think they're the most vulnerable. There's been a lot of damage throughout this country because we didn't protect children about smoking tobacco. And then we spent billions trying to get it turned around because of the health damage. And you've protected the children today. And for that reason, it's my pleasure to not only congratulate you for a lot of work done, but for doing something that's even larger, and that's thinking about the safety and welfare of our children. Thank you. I support the bill.
Senator of the 33rd, Senator Thurston, you are recognized.
Thank you, Mr. President. And I, too, would like to thank Senator Brandes for bringing this bill and really the tenacity with which you've carried this legislation and your concern about how we follow the will of the people. And I think that with our action today, that's exactly what we're doing. And this is a bipartisan issue. And I think that as Senator Rader indicates, if you look back, we've all had some concerns about the legislation, and I'm impressed with the fact that you've worked this hard to make sure that it goes through. I also voted against this legislation in a special session that we had. But the reason that I voted against it was not because I'm opposed to it. I just want to see the entire state share in the benefits of medical marijuana. We're helping people. I heard the stories. I was in the House with Senator Baxley when we were discussing this, and I heard the stories of the families who would come and talk about how the needs of the children. And I remember someone said, if it was illegal, I would have to go out and buy it on the street if that's what it took to help my child. So we don't have to do that. And with this legislation, we're avoiding that. But I'm going to vote for this today. But I would hope that we would have that same tenacity as we go forward to make sure all Floridians are able to participate in this process. And I can tell you right now, that's not what's happening. So the enthusiasm that we bring to this to help the children, let's bring that same enthusiasm to say all Floridians should participate as we move forward with this process. Thank you very much, and thanks for the legislation.
Senator Perry, Senator from the 8th, you're recognized.
Thank you, Mr. President. And while everybody's talking about why they're voting for it, I'm going to just quickly tell you why I'm voting against it. And I appreciate Senator Brandes and your work that you've done, and I think you have the right motives, and look forward to working with you on a lot of other good legislation. But, I'll read another text of the Constitution. It says, the Department of Health shall issue reasonable regulation to ensure the safe use of medical marijuana by qualifying patients, which they did. Now, a court overruled that, but that's what they did. They looked at it and said, this is the safest use, how we're going to dispense it, and that's what they did. And for me, just to think about why we're even debating smoking marijuana, I can only figure because that's the way it's been used illegally forever that we think about smoking it. I can't imagine this body. I guess we could take any medication and now say, why don't we smoke any medication? Right? I mean, there's lots of medications out there, and I think we ought to open it up to that, unless we think there's something wrong with that. Last year, I brought up there was 24 peer-reviewed medical journal articles that I had that talked about the hazards and the ill health effects of smoking anything, but specifically medical marijuana. That when you burn that and inhale it, it causes cancer. It reduces immune deficiency disorder. We're going to take an AIDS patient with an immune deficiency disorder, and we're going to say, here's a product that even makes it worse for you. Common sense, this makes no sense to me at all that we're doing this. I understand it. I understand the research, and I'm appreciative of that part in there. The research needs to be done before we implement it, not afterwards. Like you said, smoking. We're going to reap the benefits, unfortunately, down the road of the ill effects, at least from the peer-reviewed. If there's other models out there that show that it's healthy, that we should be doing this, let's get the research, and then we should pass that. But I wanted to explain why I'm voting no.
Further in debate, Senator Cruz from the 18th District.
Thank you, Mr. President, and hallelujah. 72% of the people spoke and we drug our feet, so I can't tell you how happy I am to see what's happening. 6 years ago, I was at a West Tampa Chamber of Commerce meeting, and all of this began, and the talk started. I sat with Katie Edwards, and we talked, and I thought surely the people in this West Tampa Chamber, when I asked them to take a vote, I said, let's take a vote. There were 40 of them in the room, and I thought that it would be rejected overwhelmingly. These were small business owners, many people that I've known for a long time. And they voted, and we counted the vote, and it was 2-to-1 in favor of medical marijuana. And I was shocked because I said to myself, I guess I don't know what I don't know. And I started digging in and paying attention when I realized what a small group had to say. And I walked out that day with a gentleman who's a small business owner, a very honorable man whose wife was diagnosed with cancer. And he was on the street buying illegal marijuana because it gave her great relief. And I sat in my car after I talked to him. I was very emotional about it, and I realized that these times, they were changing, and here we are today. And we talk about reasonable regulation, and people don't understand why we're going to smoke. Well, who cares? If someone is prescribed medical marijuana, let it be their choice whether they decide to rub an oil on their forehead or smoke a joint. It's their choice. They are the one with the medical need, so let's honor them. I am happy that this bill passed. If we really want to dig into issues that we're afraid of, let's dig into the overuse and overprescription of Xanax. Let's dig into the overuse and overprescription of opiates. But let's let people smoke their marijuana if it gives them relief. Thank you, Mr. President.
Further in debate. Further in debate. President Lee, you're recognized.
Yeah, thank you, Mr. President. I actually wasn't going to debate this, and I think this has been really good. And Senator Perry, I really appreciate what you said, sir. I really do, and it was well said. I've been scratching my head about this, and I'm not so sure, smart as I know Senator Farmer is, you know, and much as I respect Senator Cruz, I'm not sure exactly what was in the minds of voters when they went to vote. But I know where we're at here today, and I just want to say briefly that we're not done here. We may think we are. We're not even close to done here. I've watched this Senate and the House pass bill after bill over 22 years, and I've watched the celebration and the victory lap, and then I've watched us come back here and have to deal with the unintended consequences of what we did. And there's more coming. This is the framework that we're going to be asked to use when the next constitutional amendment passes, and that's why I've been asking some of the questions I've been asking. I'm very concerned about employers, what's going to happen in those circumstances. I understand where we are. I realize that we will pass this bill, or maybe something worse will happen than if we don't. But I just want to leave with one comment. You know, let's keep in mind that you know, capitalism does some awful strange things to people's sense of right and wrong and their integrity. And we spent years trying to deal with a pill mill problem that couldn't have possibly happened, except that some doctors were overprescribing hundreds of thousands of pills to people that shouldn't have been getting them, apparently, because we're now in litigation with all those pharmaceutical companies. Who couldn't have gotten those drugs in the hands of people unless someone was writing prescriptions they shouldn't have been writing. And we just need to be mighty careful what we do here. And I know Senator Brandes has just busted his hump trying to get this thing done and the time frame that we have. And we have very limited time to get this done. But we do, I hope, have, Senator Brandes, another bill coming. And while it primarily is designed to deal with the licensure issue, something that frankly upsets me more than where we are with this bill. I hope we can pick up on some of these latent issues that maybe still could be cleaned up when we have a little bit more time to think through them, sir. So I appreciate the opportunity, Mr. President, and Senator Brandes, congratulations.
Senator from the 22nd District, Senator Scargill, you're recognized.
Thank you, Mr. President, and thank you, Senator Brandes, for your work on this issue. This is a very hard issue. I don't agree with the amendment. I didn't vote for the amendment. I don't agree that this medical marijuana is medical or that it's even a drug, prescription medicine. I believe that it's a gateway drug, just like the opioid addictions that we had have led to the use of heroin and fentanyl. So I think we need to take these things very seriously, and I don't like the position that we're in here today. But my opinion, my personal opinion on this subject matter isn't as important. We have a constitutional amendment. We have people that voted for it. I agree with you, Senator Perry. I think the Department of Health did a great job with the bill that Senator Bradley worked so hard on, and I agree that this legislature acted in a responsible way, but the courts didn't agree, and the courts overturned it. And now we're in a situation where if we do nothing, the situation's worse. We have basically little regulation, as Senator Brandes said with the question I asked earlier. There's a whole bunch of other parade of horribles that will happen by us acting and doing nothing. So I thank you, Mr. President, for taking this hard discussion that I don't think many of us, at least in my position of not agreeing with medical marijuana, are put in. But we've done the responsible thing. You did the right thing by bringing it to the attention that we have to handle, because that's what we were elected to do. We were elected to put into place what the Constitution said. We were put in a position to make the rules surrounding it. Senator Brandes, you have put in countless hours, as did Senator Bradley before you, trying to do the will of the voters. So for that, and given the situation that we're in today, I think the responsible thing to do today would be for us to vote for this bill, to put in proper regulations, proper guardrails, so that we can enact what the will of the people was when they passed that constitutional amendment. So I'll be supporting your bill today.
Further in debate. Further in debate. Senator Brandes, you're recognized to close on the bill.
Thank you, Mr. President. In the 8 years I've been in the legislative process, every year, a woman shows up at my door in a wheelchair, and her name is Kathy Jordan, as we've talked about, and I'm sure she's shown up to many of your doorsteps as well. And she's wheeled in, and the people that are with us, describe her daily routine. And if you don't know her, she has Lou Gehrig's disease, ALS. And when the physicians first diagnosed her, they said, you're likely going to pass away within 5 years. And it's been decades now for her. And it's been decades because she believes, because she used medical cannabis. And because she smoked medical cannabis. She said it opened up her lungs. It helped with the saliva so she could eat and she could do other things. And she was the one who really worked through the legislative process. And every year she would come up, and she comes up, and she would visit us. And I think that tells the story that in the legislative process, you really need two things to be successful. You need somebody with a vision, and you need to find a champion for those ideas. And Kathy Jordan was a champion who in her quiet voice, almost you had to lean in. You almost had to sit next to her to hear her. She would tell you and advocate for smokable medical cannabis. And so I think it tells the story that as Floridians, even those of us who are in wheelchairs, even those of us who barely have a voice in this process, can be heard, can be recognized, can be respected. And this legislation, I think, honors that. I think it honors that in a way that's responsible. I think it focuses on research and shows the state's commitment to research. And I think it builds off of that research and to create a better standard of practice so that physicians will know how to properly utilize medical cannabis as we go forward. So, Mr. President, I want to thank you for working with us and your team for all of their hard work. The health policy staff has been amazing. I want to thank Representative Rodriguez for the countless hours we spent on the phone working through and negotiating some of these challenging issues. And with that, Mr. President, I'd like to ask for your favorable support to the members of this legislature. Thank you.
Senator Brandes, having closed on the bill, the Secretary will unlock the board and the senators will prepare to vote. Have all senators voted? All senators voted. Lock the board and record the vote.
34 yeas and 4 nays, Mr. President.
Show the bill passes. Read the next bill.
Senate Bill 212, a bill to be entitled an act relating to the Interstate Compact on Educational Opportunity for Military Children.
Senator Wright, before we move to you, Madam Rules Chair, for what purpose do you rise?
Thank you, Mr. President. Before we move to Senator Wright's first bill on the floor of the Senate, I move that the Senate extend the time of adjournment until 4:30 p.m.
Show the motion adopted without objection. Senator Wright, From the 14th District, you are recognized to explain your first bill.
Thank you, Mr. President. I appreciate that. This is my first bill. It's SB 212, which reenacts the provisions of law establishing and implementing the Interstate Compact on Educational Opportunity for Military Children and provides for future legislative review and repeal of the compact on July 1, 2022. The Interstate Compact on Educational Opportunity for Military Children assists member states in uniformly addressing educational transition issues faced by our active duty military families. All 50 states and the District of Columbia are members of the compact. Florida has been a member of the compact since 2008. Membership has been reinstated each legislative review in 2012, 2016, and is now scheduled for repeal unless reenacted. Because membership in the compact entails an agreement to be bound by rules promulgated by a non-legislative entity, the Compact Commission, the review provision gives the legislature the opportunity to periodically review compact rules and determine whether it agrees with any changes adopted during the intervening period. Two rules have changed since the last time. First of all, the rules formula increases the annual dues from $1 to $1.15 per military child and sets a minimum and a maximum for any state assessment. Florida's estimated dues are $45,187, which is an increase from last year's dues of $42,374. These are recurring funds from GR to the Department of Education. And the second change is the requirement that the state councils are required to meet at least once per fiscal year and submit the meeting dates, agendas, and minutes to the Interstate Commission office. And Florida Council already meets quarterly. That is the bill, and I appreciate your favorable vote. Thank you.
Are there amendments?
None on the desk, Mr. President.
Okay, members, before we go into questions, because of the volume I anticipate, I'd ask that we go slowly and orderly. Okay, are there questions? Leader Braden, you're recognized for a question.
Thank you, Mr. President. Senator, could you, well, I don't see his name. It is Wright. Senator Wright, could you tell me exactly what this bill does again?
You are recognized, Senator Wright.
Thank you. What this bill does is with the military, our active duty military, their children will move approximately 3 to 4 times more often than children that are not belonging to the military families. So the idea of this bill is to provide them additional assistance as they move from city to city and not get lost in the process, so that they stay current, because not all schools are on the same time schedule as other schools.
Further in questions, Senator Powell, Senator from the 30th.
Thank you, Mr. President.
Need microphone.
Check. Thank you. Thank you, Mr. President. Senator Wright, looking at this comprehensive bill here, on page 2 of the bill, sorry, that's page 1. It moves the date to July 1st, 2022. Why was that date picked? Was that just an arbitrary date, or does that date hold some sort of significance to this particular piece of legislation?
Senator Wright, you're recognized.
Thank you, Mr. President. July 1st has been the same date every time that it has moved forward, and it is the scheduled time period for it to be reenacted. So if we don't reenact it, it will sunset on July 1st, 2022.
Senator Powell, recognized.
Thank you, Mr. President. And Senator Wright, 2022 is an even year, and I know sometimes with this legislative process, with even years, we come to session early. Why wouldn't you pick 2023 or 2021? 2021 would allow it not to expire.
Senator Wright, you're recognized.
Thank you, Mr. President. It started on an even year, and it will continue on an even year.
Senator Powell, you're recognized.
Thank you, Mr. President. You also indicated earlier that this cost would go up from $1 to $1.15. What is the intent and purpose of that? Is there some kind of price index that cost that adjustment, or why is that being done?
Senator Wright.
Thank you, Mr. President. The dues increase was determined by the commission that meets quarterly, and they're the ones that made that suggestion for the $1.15.
Senator of the 29th, Senator Rader, you're recognized.
Thank you, Mr. President. On the date issue again, so it expires, it's repealed on July 1st, 2022. Are military children less important after that date? Is that why we're picking that date?
Senator Wright, you're recognized.
Thank you, Mr. President. In order to keep this current, the requirement is to allow the compact to be reviewed every 4 years. So every 4 years it will expire unless we reenact another 4-year period.
Senator Rader.
This is another very important question here is, in the bill, there's actually 3 words that you're adding to the statute and 1 date, 2022. 3 words, and you spoke for about 5 to 10 minutes, okay, for basically 3 words and a date. If you have a bill in the future that's maybe 1,000 words, are you going to speak for like hours on end?
Senator Wright, you're recognized.
I would suggest you pack a lunch.
On that fine response, we're moving on from you, Senator Rader. Senator Thurston from the 33rd, you're recognized for a question.
Thank you, Mr. President. And I just couldn't help for Rader to ask a question like that. Senator Wright, District 33 is in Fort Lauderdale, and we don't have the military places you have in Jacksonville. Is there any statewide implication for this legislation, or is this just something that is for your district where you're at up there?
Senator Wright, you're recognized.
Thank you, Mr. President. I'm from Volusia and Brevard County. I invite you to come visit. Bike week begins tomorrow. Anyway, to be honest with you, there's 39,293 military students that live within the state of Florida. And those are the students that we're working to protect as they live throughout the entire state, and probably some in your area.
Thank you. Members, as I said, you can never expect what's going to go on in session, and to hear Senator Rader give advice on brevity is really a first one for me. Any further questions? Senator Farmer, you are recognized.
Yes, Senator Wright, will these military children be required to get 2 doctor prescriptions to smoke marijuana?
Senator Wright.
Thank you, Mr. President. Only if they have medical needs.
Okay, Senator Wright moves that the bill be read a 3rd time by the required 2/3 vote. Is there objection? Seeing no objection, show the motion adopted. Read the bill.
Senate Bill 212, a bill to be entitled An Act Relating to the Interstate Compact on Educational Opportunity for the Military Children.
Is there debate on the bill? Debate on the bill. Senator Wright, you recognized to close on the bill.
Thank you, Mr. President. I waive close.
Sponsor having waived close, the Secretary will unlock the board and the senators will prepare to vote. Have all senators voted? All senators voted. Lock the board and record the vote.
38 yeas and 0 nays, Mr. President.
Show the bill passes. Read the next bill.
Committee substitute for Senate Bill 7006, a bill to be entitled An Act Relating to the Uniform Interstate Depositions and Discovery Act.
The Senator from the 9th District, President Pro Tempore Simmons, you are recognized.
Thank you, Mr. President. CS for SB 7006 amends the Uniform Foreign Depositions Law that presently exists here in the state of Florida, updates it, and enacts the Uniform Interstate Depositions and Discovery Act. It will replace and supersede the presently existing foreign depositions law in Florida. It provides for a streamlined methodology for foreign subpoenas to be issued in those states and still be able to be issued by or domesticated by our clerks, and will streamline these in civil actions.
Are there amendments?
None on the desk, Mr. President.
Are there questions of the sponsor? Questions of the sponsor? Seeing no questions, the Senator of the 9th, President Pro Tempore Simmons, moves that the bill be read the third time by the required 2/3 vote. Is there objection? Seeing none, show the motion adopted. Read the bill.
Committee substitute for Senate Bill 7006, a bill to be entitled an act relating to the Uniform Interstate Depositions and Discovery Act.
Is there debate on the bill? Debate on the bill. President Simmons.
Waive closing.
Waives closed. President Simmons having waived close, the clerk will unlock the board and the members will prepare to vote. All members voted. All members voted. Lock the board and record the vote.
37 yeas and 0 nays, Mr. President.
Show the bill passes. Read the next bill.
Senate Bill 7058, a bill to be entitled an act relating to trust funds.
Senator from District 7, Senator Hudson, you are recognized to explain the bill.
Thank you, Mr. President. Senate Bill 7058 creates an administrative trust fund for the Department of Highway Safety and Motor Vehicles. The trust fund would fund departmental management activities. State law recommends all departments to have such trust fund. That is the bill.
Are there amendments? Are there amendments?
None on the desk, Mr. President.
Are there questions? There are questions. The Senator of the 7th District, Senator Hudson, moves that the bill be read the third time by the required 2/3 vote. There are objections. Seeing no objections, show the motion adopted. Read the bill.
Senate Bill 7058, a bill to be entitled an act relating to trust funds.
Is there debate? Is there debate? Senator Hudson, having waived close, the clerk will unlock, the secretary will unlock the board, and the senators will prepare to vote. Have all senators voted? All senators voted. Lock the board and record the vote.
38 yeas and 0 nays, Mr. President.
Read the next bill.
Senate Bill 7060, a bill to be entitled an act relating to the termination of the Working Capital Trust Fund within the Department of Highway Safety and Motor Vehicles.
Senator of the 7th District, Senator Hudson, you're recognized to explain the bill.
Thank you again, Mr. President. Senate Bill 7060 terminates the Department of Highway Safety Working Capital Trust Fund. The purpose that the trust fund was created for no longer exists and contains no funds. It has not been used in years, so we're going to get rid of it.
Are there amendments?
None on the desk, Mr. President.
Are there questions? The Senator of the 7th District, Senator Hudson, moves that the bill be read the third time by the required 2/3 vote. Is there objection? Seeing none, show the motion adopted. Is there debate on the bill? Senator Hudson, having waived his close, Secretary will unlock the board and the members will prepare to vote.
Senate Bill 7060, a bill to be entitled an act relating to the termination of the Working Capital Trust Fund within the Department of Highway Safety and Motor Vehicles.
Have all members voted? All members voted. Lock the board and record the vote.
38 yeas and 0 nays, Mr. President.
Are there matters to be withdrawn from further consideration?
On the desk, Mr. President.
Read the matter.
By Senator Gaynor, Senate Bill 1784, relating to termination of parental rights.
Show the matter withdrawn.
The reading of the bills, Mr. President.
Madam Rules Chair, Chair Benequisto, for what purpose?
Mr. President, for a series of motions.
You are recognized.
Mr. President, I move that all bills passed today be immediately certified to the House.
Show the motion adopted without objection. You're recognized for the next motion.
Thank you, Mr. President. I move that this, just an announcement, the Special Order Calendar Group will not be meeting after today's sitting.
Did everybody hear that? You are further recognized.
Thank you, Mr. President. And the final motion, I move that the Senate adjourn until 1:30 p.m. on Thursday, March 14th, or upon the call of the President for the purpose of holding committee meetings and conducting other Senate business.
Show the motion adopted. We are adjourned.